Chapter 6. How the reformed system of procedure was received. Objections that were made to it. Recent criticisms and abuse of the system. Sec. 27. The purpose of a discussion of this subject. The purpose or idea involved in a discussion of the reception of the code system, and the objections made to it on its inauguration, and in its infancy, serves to exemplify its purposes and effect in many ways, and to show what a logical and perfect system it is. And then it is one of the interesting and instructive items of the history of the code. Sec. 28. Reception of the code by the bar. The introduction of the new system was met by the most bitter protests by some of the ablest judges and lawyers. In Ohio and New York there were many of the old-time lawyers who had practiced under the common law, who strenuously opposed the code, and consequently placed every obstacle in the way of progress which they could. A brief reference to what some of these lawyers and judges said may be interesting as well as instructive. The most bitter objection made was to the abolition of approved forms, and to the section which provided that the cause of action should be stated in plain, ordinary and concise language. Charles O'Connor, the once famous New York lawyer, said, "All the lawyers who have been admitted to practice in this state for the last 20 years are conversant with the code, and are not experts in the old common law practice." Justice Greer said, "This system, the common law, matured by the wisdom of ages, founded on principles of truth and sound reason, has been ruthlessly abolished in many of our states which have rashly substituted in its place the suggestions of socialists, who invent new codes and systems of pleading to order. That the code has destroyed the certainty of pleading. There is no one at the present day who would agree that a lawyer may be thoroughly conversant with the code procedure who is entirely unfamiliar with the common law, nor with Justice Greer that the code swept away the accumulated wisdom of ages. A lawyer who is familiar with the code and appreciates its spirit, will recognize the reason and logic of the common law. We cannot have a proper knowledge of the reformed procedure as practiced in any code state, without having some familiarity with the common law and chancery procedure." Charles O'Connor further said, "Now, according to my conception, it requires somebody much more subtle than myself or any special pleader that I have ever been acquainted with, to define or find out what it is that should be stated in the required pleading drawn in compliance with this requisite of the code. That is the one with reference to statement of the facts in ordinary and concise language. The common practice in this state is to tell your story precisely as your client tells it to you, just as any old woman in trouble for the first time would narrate her grievances, etc. This is a fair description of all pleadings that come from the office of the chief codifier himself. Meaning David Dudley Field, a demurrer to any pleading under the code is a very dangerous step, for it is utterly impossible for the keenest investigator to determine in most cases what any other reader than himself will understand to be the import of the pleadings if it be demurred to. Mr. Case, a member of the Ohio Constitutional Convention, speaking with reference to the question of certainty in the common law system said, he had seen his clients stand in amazement at hearing the nonsense read over to them in the form of pleadings which had no meaning in common sense or law. Did these common counts give the defendants notice of what was required of him? Not at all. You might as well read to him half a dozen sections from the Quran of Muhammad, as to read the common counts to him, so far as giving notice was concerned. Under these common counts a common note of hand may be introduced and recovered on, yet what notice had the defendant that this note would have been introduced? The instance of the common counts was only one of the many that might be adduced to show the nonsense and absurdity of much of our common law proceedings. With respect to these criticisms it may be stated that there was much uncertainty about the common counts. Yet as will appear later on, the courts of today still hold the use of the common counts good upon demurrer as being a sufficient statement of facts. As to the criticism of the new procedure as to what should be stated in a pleading, it may be said that it has always been a rule of pleading at common law, and especially under the code, that there must be absolute certainty of averment. Mr. O'Connor further says that under the name facts he found some things required to be stated which were neither in the vulgar sense, the mere fact or transaction or event, which did occur and can be proven by direct evidence, nor the general, rational and legal conclusions from such facts. The innovation made by the code was also retarded very considerably by the judges upon the bench, as many of them shared in the criticism to which reference was just made. The complaint was that they were not permitted to plead conclusions of law as they were under the old system. There is no wonder that there was objection to that change, because there was great advantage in pleading legal conclusions. The pleader could place whatever construction he pleased upon the facts and plead them in his own favor. It is not for the pleader to place the construction upon the facts, but he must state them as they are without color, and let the court draw the legal inferences. To show how the courts shared in these criticisms, a quotation is made from Judge Sutherland, in the case of People v. Mayor, 8 Abbott's Rep. 7, as follows: "If I understand the code, and the tenor of the spirit of the decisions under the code, the plaintiff may present in his complaint a mass of heterogeneous facts, and a volume of unmeaning words, and in the number of prayers for the most various and inconsistent relief, and none of these defects can be reached by the demurrer, provided the complaint contains, no matter in what state of disorganization, the elementary constituents of a good cause of action. On a demurrer to such complaint, on the account that it contains no cause of action, it is the duty of the court to uncover the mass of heterogeneous facts and to sort them out and arrange them, and if found that any lot or parcel of them when arranged and put together, will stand alone as a cause of action, it is the duty of the court to overrule the demurrer. The remedy for such difficulty is very plain and simple. If there is any uncertainty or any improper allegations, it may be readily corrected on motion. This argument seems much out of place after so many years of successful operation of the code. If the facts were in such heterogeneous state, if there were irrelevant, impertinent, redundant or superfluous statements in the complaint, it could have been easily remedied by motion. It is true that in the manner of the statement of the facts constituting a cause of action, the code made a very radical change. It struck down many of the old pet forms. But the rule as to the statement of facts is plain and simple. There were several general rules which covered the objections made by Judge Sutherland. A motion could have been made to strike out or to make definite and certain. The nature of the changes made by the code will be discussed, and an answer to the objections made to it will be considered in another connection. Sec. 29. Feeling and experiences of lawyers on the eve of the inauguration of the code. The following from the pen of Judge Yappel aptly expresses the situation and feelings of the lawyer at the time of the adoption of the code. But, on July 1, 1853, the technical learning and rules of pleading at common law and in chancery were, except as to cases then pending, swept away by the taking effect of our present Code of Civil Procedure. After its passage and before it took effect, it was carefully read, with the report of the commissioners who framed it and Vance and Vaughn on the New York Code, 5 times, and the writer flattered himself that he was already fitted for an adept in practicing it, though by no means thinking, as many seem to do now, that its object is merely to permit anything to be done, in any manner. On June 30, 1853, a large railroad contractor failed and absconded. With night came many anxious and excited creditors, impatient to bring suits and attach property to secure claims. At midnight the old system would die, and, immediately after, the code be born. Petitions, affidavits for attachment and garnishment, forms of undertaking, notices of garnishes, what the clerk should do, directions under the code to the sheriff, etc., were to be prepared. The doubts, the embarrassment, the confusion, the uncertainties, and hesitancy, when dispatch was imperative, with no decided case to guide, and Tidd, Chitty, Swan, and Wilcox inapplicable, if not wholly unreliable, cannot now be fully realized by the code practitioner. With these books upon the table, the exclamation was, "Oh, my masters, friends, and guides, are you all dead too?" lying there before me on the cooling board. Apostrophe. The experience of the whole bar was the same, the old lawyer as helpless as the young, and all had cases to bring that night. There was, during those distressing hours, occasion for the employment of the recording angel's tears to blot out the imprecations on the code, bestowed upon it so plentifully. Sec. 30. An argument against the code, in contrast with the argument of the Code Commissioners, is that of Simeon Nash, author of Nash's Pleading and Practice, who was very much opposed to the code. Speaking of the section which abolished all of the forms of action, he says, The code reverses the scientific process, ignores all classification and throws the old science into a single class, into a multitude of individual facts without any law of aggregation or arrangement. The law started in the remote past from this point, and has, under the so-called spirit of reform, but really of destruction, again returned to it. In no other science would such an absurdity have been tolerated, nay, not even thought of, but to be ridiculed. There is now to be but one form of action. This cannot be. The form of an action is the manner in which the facts constituting the action are to be stated. This statement must be as various as are the facts which constitute a right of action. The construction to be given to this language must be that there is to be but one kind or class of actions, while the form of each action must correspond to the nature of the facts and law on which it rests. The form of an action founded on principles of equity must always differ from one founded on legal rights, while an action to recover a sum of money must in its form, ever differ from one to recover specific real or personal estate. The code then creates a single class of actions, makes every action an action on the case, an action on the peculiar facts of that case, without any regard to classes of actions, and yet this very effort to ignore classification is violated, since the code speaks of actions to recover money, to recover specific real property, to recover specific personal property, and all other actions. Here are four classes of actions distinctly shadowed forth, and which, being founded in the very nature of things, will undoubtedly become the origin of a new classification of actions to grow up under the code itself. These will again give occasion for subdivisions, until order shall be educed out of the chaos created by the code. The human mind must classify and arrange, and even legislation cannot prevent it. The whole body of the law, whether administered in a court of law or in a court of chancery, is left in full vigor. The remedy, not the law, is changed. Nor does the remedy indeed seem to be changed, it is rather the name than the thing. The object heretofore sought by a bill in chancery must still substantially be sought by the same means. Though now called a civil action, instead of a bill in chancery, and an action on a promissory note, or other contract, must still assume the shape of an action at law, though under a new name. The law remains the same, facts will repeat themselves, and a cause of action cannot be stated very much differently from what it has heretofore been stated. Where the facts and the law are the same, the cause of action must be stated substantially in the same form, and hence a new classification will gradually grow up under the code, as it grew up under the common law, but not with the same rigidity, since under the code, classification will be a mere matter of convenience, and not a law of necessity, so that an action may be amended from the one class into another, according to the nature of the case itself, as developed in court. Sec. 31. Some recent criticisms of the code. The original Field Civil Code in New York contained but 391 sections and was pronounced a very wonderful piece of legislation, concise and comprehensive. The revolutions it instituted, the extent it is difficult now to understand, were wholly, as everyone knows, in the law relating to pleading and procedure. Had crafty, debased and unsystematic legislation refrained from meddling with the primitive practice code of 1848, there never would have been valid cause for dissatisfaction with those reforms which Mr. Field originally contemplated. Indeed, today, if there were the slightest efforts in the right direction, the adjective law of New York, with all the light of experience, might be readily made the best instead of almost the worst in the world. It is said of the New York Code that by 1880, by reason of numerous decisions and amendments, it had become an unwieldy and inconsistent mass, so that a new codification was necessary. A recent writer upon the subject of law-making, in speaking of the New York Code, says that if this new code has again, in 16 more years, through the operation of the same causes, become so uncertain and obscure that no lawyer can know the practice by reading the code itself, but must consult the congested volumes of the annotated codes and hundreds of volumes of reports of practice cases decided under the code, what will be the fate of a civil code? Speaking of the union of law and equity, the same writer says, the union has been more apparent than real. In the old practice a separate judge sat for common law cases, and a separate judge for equity cases. One set of cases was tried by a judge and jury, the other by the judge alone. The New York law reform did not attempt to do away with this difference in the trial tribunal. In consequence, the courts have had to keep up the distinction between law and equity. The codifiers could not do away with the jury in common law cases because it was protected by the Constitution. The code expressly prescribed that the jury should try common law cases and the judge all others. The consequence was that the continuance of the two tribunals necessitated a continuance of the division line between the systems. The Great Reform, therefore, resolves itself into the same judge sitting, now as a chancellor to hear a case of equitable fact, and now as a common law judge with a jury, to hear a case of common law facts. The total amount of the Great Reform is to occasionally compel an equitable defense, when interposed to a legal cause of action, to be tried before a judge and a jury, instead of before a jury alone. If, however, the equitable defense is also a counterclaim, the counterclaim must be first tried before a judge alone, before the legal issue is brought on before a judge and jury. Thus if a landlord sues for rent on a lease and the tenant sets up a counterclaim to reform the lease for fraud or mistake, the counterclaim must be tried in equity before the rent issue is tried. The disadvantage in common law practice is well illustrated in Johnson v. Allen, 22 Florida 224, 1 A.M. Street 180, a common law state, where it was held that an equitable plea could not be set up in a common law action, that when such plea is filed it may be stricken out on motion. Continuing, this writer further states, in fact, the continued separation of the two systems is still so complete that the court is divided into the equity and common law part, and the question of whether a case shall be tried in one or the other is a question of calendar practice, instead of a question of jurisdiction. Under the old practice, if you sued in equity when you ought to have sued at law, or vice versa, your suit was dismissed with costs, and you had to start over again. Under the present practice, provided the facts set out in your pleadings are the facts you prove, the court will decide the jurisdiction questions and give you one relief or the other. But, should you bring on the case at circuit when the judge thinks it ought to be at special term, you get your case dismissed and delayed until you get it on the calendar of the right part. Again, it is held if a party bring an equitable action, even though the same court administers both systems of law and equity, the party must maintain his equitable action upon equitable grounds or fail, even though he may prove a good cause of action at law on the trial. The same author says, across the Hudson from New York State, the state of New Jersey has effected reforms in its chancery and common law practice, without the aid of a code of civil procedure. A statute prescribes that witnesses may be examined viva voce in an equity case as in common law. The anomalies and absurdities of common law and equity pleading have been removed by a few short rules of practice. Besides the code and the cases under the code, the New York practitioner must consult an octave volume of court rules. In New Jersey, a small book about the size of our New York rules of court practice embraces the rules of procedure of all her courts. A short practice act, taking up a few pages of the revised statutes, takes the place of the first half of our Code of Procedure, with its 3,397 sections. And it is probably within the truth to state, that the number of reported cases on practice questions, in New Jersey, would not exceed the number of volumes of reported cases on practice questions in New York since the Code. An eminent New Jersey counselor informs the writer that in 20 years' practice before their courts, involving an average of 20 cases a year in their court of errors, he has had but one practice case that has gone to the Supreme Court for decision, and that case involved the construction of a section of the New York Code of Civil Procedure. The reforms in New Jersey have been accomplished by changing or recasting a few rules of common law and equity, the good body of the system being retained. In this simple way their practice has been modernized, and the defects of the old systems removed. It may well be doubted, therefore, whether New Jersey has not chosen her course of law reform more wisely than her more populous neighbor. Again, in England, the reforms in judicial procedure have been effected by the Practice Acts of 1873 and 1875, supplemented by the rules of court enacted under their authority in 1873 and 1883. How they have worked it would be interesting to learn from those practicing under them. The absence of any trenchant criticism, or of any marked attempt to change them, would seem to indicate that they have reasonably affected their objects. Sec. 32. Abuse of the system. The code system of pleading and procedure has not been without its abuses. There are so many preliminary, technical, time-consuming controversies that are very annoying. Courts spend entirely too much time in hearing and determining technicalities, intricate questions of pleading and practice, which in no possible way benefits the court, or the parties, but on the contrary do a positive injury to both lawyer and client. There are so many motions and preliminary contests which do not concern the merits of the case and serve no useful purpose. There ought to be something done which would prevent such waste of time and labor. There should be fewer motions, less time and labor spent on technicalities and more in arriving at the real merits of the controversy between the parties. A lawyer who desires to serve his client and to make his profession dignified and honored ought not to file petty motions, which raise merely technical questions which do neither himself nor client any good. This kind of practice does harm to the profession, and breeds a practice almost as harmful as some of the evils of the old practice. As the Code Commissioners said, delay and technicality in pleading are discouraged.